and fixed up front and maintained ends up being significantly cheaper than just letting something blow up and then cleaning up the mess later. And there are a lot of attorneys who are very happy to do that. Maybe you could elaborate why every client has a fundamentally different trust. For each client, do you do hours of case law research and then come up with some creative, new, innovative trust that the world has not seen before? I just don't seem to see that. My gut is that it just physically takes a lawyer X amount of hours to rewrite a standard trust template, and a lawyer generally charge Y amount of dollars, which is why the costs are the way they are. All right, remember this old joke? This was even before I became an attorney. That someone goes to an auto repair shop. My car's not starting. And the mechanic goes over, looks, tests a couple of things, grabs a wrench, turns something, car starts right up. It's fine. All right, that'll be $300. $300? All you did was turn that wrench. Yeah. But you're paying for all of the years of experience I've had to know which nut to use the wrench on. That's what we're talking about here. After 26 years, I know what wrench to use on which nut to make the whole thing work, and it's dozens of these different things. But yeah, if you start from the same type of template for different categories and situations, you adjust it. You're paying to make sure that it's done. You're paying for the peace of mind, not for the turning of the wrench. Okay. Doubt. I engaged you sincerely all over this thread and you dismissed me offhand. Forgive me, but this particular post I responded to was easily your least intellectually engaging post yet. Those short, succinct answers are the right ones. I feel sorry for your family and the mess you seem hell-bent on leaving them. OPS, sorry I didn't see your reply on the other thread, so apologies. It was a thoughtful response that I do appreciate. Let me address your edit in a separate post. Okay, per your edit, third and final paragraph, your gut is exactly right. You aren't drawing the right conclusion from it. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. Okay. I charge far more than it would take a paralegal being paid at paralegal rates to draft up a trust instrument. In fact, attorneys are not even particularly great drafters, which is why a lot of us, including me, pay a lot of money for drafting software to keep our documents consistent, well organized, and, knock on wood, free from major errors. The end result is quite a lot like what you've seen across 3 revocable living trusts done for a family. You might well see nearly identical documents. Now, most attorneys are going to give a discount representing 3 linked families at once. But in any case, we could still easily be talking tens of thousands of dollars, and that's a lot of money. And now I'm telling you that a lot of cases, those documents are going to be 90 to 95% identical. Yep, that's exactly what I'm saying. I'm also suggesting quite overtly at this point that you're paying for far, far more than pieces of paper. What you're paying for is expertise. A pair of eyes and a sharp brain, and many times much more than one set of each, who can simultaneously problem spot all the myriad complexities you had no idea about. I bet you didn't know IRAs and minor children was such an enormously complex scenario, and come up with solutions to resolve them. Here's the next level. Would you be happy with any attorney who required you to pay to make an amendment to your trust every time you wanted to make a tiny little change to your estate plan? Sometimes it's inevitable, don't get me wrong, but a good attorney is going to create a living document, one that can be amended, sure, but if done right, one which will also leave an array of options on the table that won't involve expensive upkeep. I can't tell you the number of times I've stopped clients from putting charitable bequests into their will or trust, knowing they will have to pay me every time they want to change the amount. Instead, I often direct them to beneficiary designations for charities, knowing full well that tweaking them over time is much, much easier than working with me. Yet for all my guidance and foresight, I've now produced for these same clients an even more boilerplate document after all their charitable bequest was nowhere to be seen in it. And you don't have any idea about all that I touched on, every single asset to have everything properly considered. Good estate planning is just as much about the professional as it is about the quality of the documents. As time goes on, it seems like complexity is increasing, not decreasing, and that points to working with a professional, in my incredibly biased opinion. Very, very well said. The poster just seems to think that attorneys who do estate planning are document salespeople, and they're not. Imagine a car salesman. Oh, well, yes, I want you sell this and we get this feature and we can swap this out. And it's like, yep, it's the same basic car, except we've adjusted these things. It's done. They didn't build the car. They didn't work on the car. They didn't customize the car. They just sold it. That's the way this person who's posting on Reddit is looking at estate attorneys, as if they're document salespeople. And it's not that. They're the ones actually using the tools to build the car for them. Thank you, and I appreciate you taking the time to type that all up. It is actually incredibly helpful to hear exactly your perspectives. I do hope this thread will benefit others in the community who are probably thinking the same thing. Same thing as you? I don't see anybody so far. No problem. I spent all day writing legal blog posts for my firm. I'm obviously in a writing mood today. Just being polite. And I'll grant that OP is accurately describing most or all trust mills. All right, that's actually a separate problem. Trust mills are document production companies that have unskilled people trying to sell them and then trying to get somehow or another. It's usually a financial advisor who has stuff to sell, who's pushing them, and there's no attorney interaction, or very, very little, just enough to try to squeak by on state rules about the unauthorized practice of law. There are other companies out there, like the one I work with, the estate planning source, where this is an integrated process with a lot of attorney involvement, interaction, and in particular input on the documents themselves as templates for different states update and different things come around. This is that's a top-notch company, but the trust mills are just there to try to help. Usually it's life insurance or annuity salespeople get in the door, and they're not actually doing a good product. They don't care. The trust is a, quote, loss leader. I care about making very good quality documents and plans for my clients and putting it all together in the right way. But the trust mills that are out there, they're selling paper. However, the actual work is in the planning phase and execution/funding phase. I draft basic documents in minutes, not hours. I'm not going to lie about that. It takes far more time for me to review it and add comments. Such a plan where we spend hundreds of hours would cost hundreds of thousands of dollars and might not even work. Yes, we fit the client to the plan in the same way a tailor will fit you to a suit. Very good analogy. The better the tailor, the better the fit, but we can use an off-the-rack suit in many cases. All right, that actually is a very good way to put it. Yeah, oh, it's just a suit off the rack. Why can't I just take it and do it? Well, look, if you're not a tailor, it's not going to fit. It's not going to do what you need it to do. Estate plans are substantially different from client to client. A cookie cutter approach is bad to use because there is a substantial risk the intent of the decedent or settler will not be achieved, which could mean a lot of things, such as your assets ending up with someone other than your intended beneficiaries, like a creditor, or a family member you utterly despise, ending up with care and custody of your minor children. Unfortunately, there are a significant number of attorneys who do not have any specific expertise in estate planning, who prepare estate plans as a part of a general practice, usually because they think it is easy, quick money. These attorneys may produce estate plans that appear to be cookie cutter, and frankly, they contribute to the public's perception that estate planning is simply a matter of replacing names on a form. Well, and that's a good point. I call them also attorneys. Yeah, I have a good real estate practice, but I can also do, a will. And, oh, well, I've got a great divorce law practice, and yeah, I suppose I could also do some trust and do it on the side. They're not concentrating on it like estate planning attorneys like me and most of the posters here, the attorneys who are posting. They don't know that they have as much of a problem as they really do, until it comes back to bite them when one of the plans they did blew up. DIY plans are fine if you genuinely don't care what happens to the things and people you leave behind. The passive aggressiveness you see stems from the disrespect and ignorance inherent in the question. We spend $250,000 in days, nights, and weekends for decades obtaining the education, training, and experience necessary to perform a service, and people turn around and ask us, how complicated and difficult could it possibly be? Surely you can imagine why we are perfectly happy to let them disregard our counsel and charge their beneficiaries 10 times the fee to clean up the mess we tried to prevent. Very true. Trying to get stuff done and prepared and fixed up front and maintained ends up being significantly cheaper than just letting something blow up and then cleaning up the mess later. And there are a lot of attorneys who are very happy to do that. I don't happen to be one of them. That's not the kind of practice I want to be in. But do it yourself. It ends up blowing up and the attorneys end up making a lot more money. And you kind of get to a point when all of that knowledge, all of that experience, all of that work is just kind of like, well, how hard could it possibly be? You're just changing names on a form. You basically want to say F off. They have no idea. Fine, we'll make money on the back end. I heartily agree with all of this. You have it backwards. We fit the client to the cookie cutter, not the other way around. Cutting the client is both bad to do, and answering the actual question using the wrong plan for that client is going to cause a lot of problems later on. Very true. If you end up just copying a plan from a family member who has multiple children and but there are no issues, and then you go ahead and take that same trust, but you have a child who's disabled and receiving Medicaid and you don't have the right provisions in there, it's gonna blow up. And it's gonna end up either disinheriting your your child, or they're going to end up losing all of their benefits and wasting the money. And that's just the way it is if you're copying someone else's plan. People have actually answered multiple times throughout the thread that a major issue with DIYing is that you will almost certainly fail to fund your trust properly. That's a huge thing too. The trust document you need may be exactly word for word a boilerplate one, but that doesn't help your beneficiaries at all in the future if you miss some assets and it still ends up tied up in probate. We have a whole webinar and a whole course on trust funding. And part of what we generally are doing, occasionally when we see clients that need a little extra help, we're going to give them like a 3-month pass for that course. So trust funding course webinar is the free one. And there's going to be a link in the description below to the actual course. But it's trustfundingcourse.com. All right. An individual person is in a uniquely poor position to judge the complexity of their own estate. 1, you're the number one expert in your own life. Everyone else will have a far harder time administering your estate than you would, and you're the one person who can't do it. 2, unless you're an attorney practicing in 2022, you have no idea what complexity looks like. $5 million in investable non-qualified public securities is easy. $32,000 in a qualified retirement account with a 6-year-old, arguably one of the hardest, most complex situations in law right now. 3, a trust plus will isn't a thing. In spite of the immense irony that I did in fact once represent a DIY estate with a trust plus will, it's in a 7-year-long probate and shows no signs of stopping. If the aggrieved brother has anything to say about it, he pulled a gun on the surviving spouse a few months ago too. But I digress. If you can't ask your question in a way that makes sense, to be clear, I am confused by whether you're talking about a revocable trust versus a testamentary one. What chance do you think your beneficiaries have? At the end of the day, you're paying for peace of mind. And in most cases, you're getting what you pay for with free or discounted advice. And make no mistake, I include myself and r/estate planning in that. So the advice is universal. This is just not good for you. Don't do it, don't do it, don't do it. And here we go with a response. I appreciate these thoughts, and I do apologize if I'm not asking my question correctly. So I posted this reply in another thread, but I believe you do see the worst case stuff just by the nature of your job. In other words, I don't believe you. Okay. Maybe another way to phrase the question is, how often does it go wrong? Excuse me. I guess the question is a bit rhetorical in that I am sure no one knows the answer. Yeah. My gut is that 99.999% of the time an online solution is just fine. I know you would disagree, and I would too from your perspective. You again only see the worst stuff. It doesn't apply to me. I think you're right in that ultimately you're paying for peace of mind, and that actually seems so far to be the only logical reason. So I'll rephrase the question. If I am paying for peace of mind, how do I compare one estate attorney versus another? Okay, finally a reasonable question. But I still, at this point, I just get the impression that he's just not going to follow it. He just doesn't know. And when he gets the advice, he's going to ignore it anyway because he's going to do what he wants to do.